Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we are going to talk about a case that, well, it's about as old of a case as you could think of that still hasn't come to final resolution. Of course, I'm talking about Duncan v. Bonta, the challenge to California's magazine ban, a case that actually got started years and years before we even thought about having a channel called Washington Gun Law, and a case that apparently has no end in sight. Well, the plaintiffs in that case have finally had enough, and they have petitioned, yet again, to the United States Supreme Court. We're going to go over that petition today. We're not going to necessarily talk about the legal arguments because, well, we've gone over those 1,000 times, and if you geek out with us on any kind of regularity, you already know the arguments. But we are going to talk about another theme that's in this brief, and one that I really like. So today, let's spend a few minutes and let's talk about the case that challenges the Supreme Court to do its job. Okay, America, we are talking about a case that we have talked about, well, since the inception of the channel. Every other content creator has talked about it dozens and dozens of times. It is, of course, the case of Duncan v. Bonta. This is a challenge to California's magazine ban, which predates just about everybody else's magazine ban. Now, I could do a whole 3-part video series just going over the history of this, but we're not going to bore you with that. What we are going to talk about, though, is the arguments that are being brought by the plaintiff, not so much the legal arguments that you expect, in common use, dangerous and unusual, all of the very rather straightforward arguments that apparently the Ninth Circuit cannot seem to get. But we're going to talk about a challenge, essentially, that is put into this memorandum that is basically asking the Supreme Court, hey, when are you going to do something about this insanity? And it's one of the most frequent questions that I get, which is, when is the Supreme Court going to do something about it? And, most recently, I thought we had a golden opportunity to do exactly that, and here we are still talking about it, right? Okay, now, before we go any further, though, I do want you to know that the California Rifle and Pistol Association has been on this ride with Virginia Duncan since day one, okay? And if you're looking for a state organization that absolutely, truly knows how to fight like holy hell, it's CRPA. Now, it's probably because the state gives them so much to work with and they are so battle-tested, but we're going to put a link for them down below. California, if you're not part of CRPA, you better get down there and show them some love. Okay, now, this is what I want to talk to you guys about. What I love about this memorandum, obviously the law stuff is there, but we geek out on that all the time. We're going to talk about something else today, a little different flavor, which is that CRPA and the petitioners here really kind of asked the Supreme Court, hey, do you have a backbone? You going to do something about it? Let me show you how they start. When this court vacated and remanded the prior judgment in this case, in light of Bruin, one might have expected the Ninth Circuit to reassess its decision to bless California's sweeping ban on long lawful magazines. After all, Bruin reiterated that the Second Amendment protects the possession and use of weapons that are in common use at the time. And given Bruin's reaffirmation of the rule of decision that controlled Heller, that states may not ban arms that law-abiding citizens typically possess for lawful purposes, it should have been easy to see that California's ban on feeding devices that can accept more than 10 rounds of ammunition violates the Second Amendment, as tens of millions of law-abiding Americans lawfully own hundreds of millions of these devices as integral components or constitutionally protected and legal firearms. Now, for those of you who've been along for this horrific roller coaster ride, you will recall that Judge Benitez at the trial court level, he always seemed to get it right. 3-judge panels would attempt to get involved, but that's when we always saw these irregularities with the full en banc panel jumping in, sucking it up like a Hoover vacuum cleaner, and then starting to play their games. Always, of course, finding ways to uphold it. This, of course, leads the petitioners to point out, for the district court, that was indeed easy to see, but the Ninth Circuit would have none of it. The court bypassed the ordinary panel review process, reconvened an en banc panel that now consisted mostly of judges not in active service, granted emergency relief to the state over the dissent of most of the active judges on that panel, and ultimately held that California's sweeping and confiscatory ban on some of the most common arms in America does not implicate the Second Amendment right to keep and bear arms. Now, I want you to think about that, okay? Because initially, this was always upheld under a two-part balancing test. Yeah, it might be a violation of the Second Amendment, but when we weigh that against the benefits to society as a whole, it's a permissible violation, okay? Then, of course, when the court takes away that balancing test, the only way that an intellectually dishonest court can get there now is to suddenly believe that, well, magazines are not even covered by the Second Amendment at all, which is exactly what the Ninth Circuit and several other circuits, Seventh Circuit, Fourth Circuit, for example, have done as well. That decision cannot be reconciled with this court's precedents or the constitutional traditions they embody. Indeed, despite professional surface-level adherence to Heller, Bruen, and Rahimi, the Ninth Circuit ultimately cast those decisions aside, pawning off interest balancing as careful consideration of constitutional text and historical tradition. And that is what not only the Ninth Circuit has done, but a lot of these other courts are doing. So whether it's in common use for self-defense or uniquely dangerous or more useful for military service, they have allowed those types of balancing tests, which of course then the court becomes the great keeper of, right, to be re-injected back into the equation, despite the fact that the equation does not require nor permit any of that. But this allows them to continue to put their thumb on the scale, exactly what Bruen was supposed to alleviate. And of course, the Ninth Circuit has developed quite a reputation. The only thing more patent than California's disrespect for those rights and the people to whom they belong is the Ninth Circuit's disrespect for this court and its place in Article 3 hierarchy. I mean, in many ways, what the Ninth Circuit has done, and again, they're not totally alone, but they're probably the most egregious violator of this, is that they have committed a complete mutiny upon the United States Supreme Court. Now, because some circuits are willing to adhere to the true constitutional standards, while others, like the Ninth Circuit, are not, we have circuits that are all over the board as to whether or not even magazines constitute arms. An issue, by the way, which could have been resolved with the acceptance of Ocean State Tactical, but I digress. Now, this does make this issue, again, theoretically, more ripe for accepting review by the United States Supreme Court. The petitioners wisely point out, in sum, the circuits are divided both over whether magazines capable of holding more than 10 rounds of ammunition are arms at all, and over how to determine which arms are ultimately entitled to Second Amendment protection. That vividly illustrates why this court must provide more guidance on those critical questions. And all the more reason we spent, the better part of the springtime patiently watching for both Ocean State Tactical and Snope v. Brown. But again, like I say, here we are. Now, here's the unique thing about California's magazine ban that some of you in other states, including here in Washington State, may not have to deal with. See, we grandfathered our magazines in, so you can still possess them, you can still carry them. You just can't go buy any new ones anywhere in this state. California, they banned the possession of it as well. Now, here's the deal. If you own 50 magazines that exceeded 10 rounds, which again wouldn't be crazy, and suddenly you can't use any of them, well, those things are now worthless. But have you been compensated by government for essentially what is the takings of your property? Because that's what the Fifth Amendment requires. And so the unique thing about California's ban is it actually implicates not only the Second Amendment, obviously, but also potentially the Fifth Amendment. And the petitioners pointed out this way. California's decision not only to prospectively ban commonly owned magazines capable of holding more than 10 rounds of ammunition, but to confiscate them from law-abiding citizens who lawfully acquired them long before the ban was enacted, is one of the rare government initiatives that violates not one, but two provisions of the Bill of Rights. The Ninth Circuit's contrary holding, finding no takings clause violation, is profoundly wrong. And I actually, in some ways, agree with that because there is not nearly as much interest balancing and gamesmanship that can be played in the unconstitutional takings arguments under the Fifth Amendment than all the gamesmanship that, well, courts like the Ninth Circuit have created over the last few decades. But at the end of the day, is this going to get anywhere? I don't know. Has this case percolated enough? There is no case that has percolated, especially on magazine bans, more than Duncan v. Bonta. This case has aged out well beyond fine wine at this point, all right? So we're going to have to carefully watch this case to see, Does this actually go anywhere? If ever there was a magazine ban case, however, that deserved to be the lead case to once and all ultimately decide this issue, it would be Duncan v. Bonta. Okay, listen, we're going to go ahead and link up the petition for review down below. Remember, there's a link down below for you to show California Rifle and Pistol Association some love as well. Now, listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.